Hello dear students, today our topic of deliberation is Origin and Development of Law of Torts in India and England. Before going through this topic, first let's have a look on its objectives. First, the basic principles of law of torts. Second, the concept and development of law of torts. Third, the remedies available in the law of torts. The word tort is a Latin term which means tortum, which means twisted or wrongful. In this context, it is the equivalent to the English term wrong. The term tort was introduced into the English law by Norman jurists. In due course, this term was used for those special wrongs for which English courts allowed action in tort for giving remedies. Thus, it consists of those wrongs or unlawful acts which violates legal rights of a person for which law provides the remedy of unliquidated damages. It is the duty of every person to respect the legal rights of others. If a person violates his legal duty, he does a wrongful act, and if by his act an injury is caused to the legal right of a person, then the aggrieved person can file a suit against him for damages. The law of torts as administered in India is the English law as found suitable to Indian conditions and modified by the Acts of Indian Legislature. Its origin is linked with the establishment of the British courts in India. The law of torts was introduced through these British courts. The first British court introduced in India was Mayor's Court in three presidency towns of Calcutta, Bombay and Madras. These courts were established in the 18th century. The charters which established these courts introduced the English common law and statute law in India. Later on, these courts were replaced by the Supreme Court in these three presidency towns, but similar jurisdiction was conferred upon them. The Supreme Courts were superseded by the High Courts in these three towns, but the jurisdiction to administer English common law was continued. The law of torts is a branch of English common law, and it was in this manner that the law of torts was administered in the provinces of Madras, Bombay and Calcutta. These courts have been established by acts, and the acts which establish them contain a section which requires them, in absence of any specific law or customary law or usage of, to act according to justice, equity and good conscience. The expression justice, equity and good conscience has been held to mean rules of English law so far as they are applicable to Indian society and circumstances. Thus, the law of torts was administered in the High Courts of Bombay, Calcutta and Madras in their original jurisdiction, as it was introduced there by charters. In other courts in India, the English law of torts was administered as a principle of justice, equity and good conscience. In India, the law of torts has not been fully codified and it is still based on common law of England. In absence of codified law, Indian courts apply the rule of justice, equity and good conscience. Dear students, let's discuss the reasons for slow development of law of torts in India. In India, the process for development of law of torts started very late. The development of this branch of law in India started simultaneously with the modern scientific development. Large parts of the Indian population are poor and illiterate. The cost of litigation in India is very high. This is one of the biggest obstacles in the development of law of torts in India. On the other hand, the administration of justice in England is simple, inexpensive and speedy, as a result of which there has been so much development of law of torts in England and is still developing. In short, the slow development of law of torts in India may be summarized as follows. First, uncertainty of law. It is well settled that law of torts is not codified and is still developing. Due to uncodification, there is no uniformity and certainty in its rules and doctrines. Due to developing law, there is lack of precedents in every situation. Second, lack of political consciousness. Due to lack of political consciousness there, most of the people are not aware of their rights. A large part of Indian population is illiterate and are not aware of their rights. Third, illiteracy. The main reason for the ignorance of their rights is illiteracy. Fourth, poverty. Poverty is another major factor for the less number of tort cases in India. Fifth, expensive and dilatory judicial system. Indian judicial system is very expensive and dilatory. The rate of court fee and lawyer's fee is very high. Consequently, the poor, instead of going to the courts, suffered the violation of their rights. Indian law is practically English law. The law of torts as followed by the courts in India is mainly the English law of torts, which itself is based on the principles of the common law of England. Indian courts are bound to administer the English common law rules only in so far as they are consistent with justice, equity and good conscience. But apart from certain exceptional cases, our courts invariably follow English principles for all practical purposes. In order to understand the basic principles of the law of torts, we have to understand the application of English law. English law is mainly built up of case law. It is said to be a stately edifice of case law. There are only a few statutory enactments concerning this branch of law. Now, let's understand the importance of the forms of action. The clear divisions of modern law into contracts, crimes, torts, etc. were unknown to ancient law. In early days, the ritual of legal procedure completely dominated the substance of legal right. It was only very recently that the judges began to ask the questions in cases before them. Has the defendant infringed any legal right vested in the plaintiff? Has he broken any duty which he owed to the plaintiff? On the other hand, their task was to find out whether the plaintiff's case can be brought under any of the pre-existing recognized forms of action, irrespective of the question whether a substantial right of his had been infringed or not. In short, the question they invariably put was, has the plaintiff any form of action against the defendant, and if so, what form? If he could not fit his claim within any of the recognized forms of action then existing, it was likely to be dismissed. Now, dear students, let's discuss writs. In early English law, remedies for wrongs were dependent on writs. The writ was an order of the king issued by the chancellor or his office, summoning the defendant to appear before court and show cause against the plaintiff's complaint. No one could bring an action unless he obtained a writ from the covered development, which was a government department invested with the powers of issuing writs. Suitors had to pay a price for the issue of writs in their favor. If an injured party purchased a wrong writ, or if he could not fit his claim within any one of the pre-existing writs, then even though a substantial right of his had been infringed, he would still have to go out of court without any redress for his grievance. Ubi remedium ibigus, where there was no writ, there was no right. Sir Henry Maine has correctly explained the nature of early English law in the following words. So great is the ascendancy of the law of actions in the infancy of the courts of justice that substantial law has at first the look of being gradually secreted in the interstices of the procedure. Now, writs of trespass and trespass on the case. The writs that remedied the injuries which in modern times are called torts were at first the writs of trespass and later the writs of trespass on the case. The word trespass in common parlance means and signifies any unauthorized entry on another person's land, but in law it has a much wider significance. The writ of trespass lay for injuries to land or to goods or to the person, but it was limited to injuries which were direct and immediate, such as that occasioned by throwing a log directly onto the road and it hitting a man there. It did not extend to indirect or consequential injuries such as those sustained by one who subsequently stumbled over the log. But these came to be remediable by writs of trespass upon the case, which were simply writs of trespass adapted to meet the special circumstances of the case. By an enactment in Edward I's reign, the famous statute Consimile Casu of 1285 AD authorized the Office of Chancery to issue writs in case of new injuries, fresh writs of trespass upon the case, to meet the needs of such injured persons. Probably by virtue of this enactment, we find in later years clerks in the Chancery issuing new writs to suit different cases, which made it possible for the law to develop to its modern shape. All these writs were supposed to be offshoots of the mother writ of trespass, which is called by legal historians of English law as the fertile mother of actions. In an action for trespass, the act of the defendant need not be willful or intentional. Thus, in the case of Lame versus Bray, the defendant was held liable in trespass for driving his carriage so negligently as to cause a collision with that of the plaintiff. The driver had not caused the collision willfully, but the court said, there being an immediate injury from an immediate act of force by the defendant, the proper remedy is trespass, and willfulness is not necessary to constitute trespass. Now, dear students, let's understand early writs for contracts. The early remedies for breach of contract were the action of debt, action of covenant, and the action for detinue. The action of debt was a claim for the restoration of money. Under these early writs, there was no great scope for the development of law to cover all the different varieties of action now deemed to be contractual. But in the 14th century, a new remedy was introduced, which was destined to have a remarkable effect in the development of the law of contracts. This was the action of assumpsit, which in fact was a variety of the action of trespass on the case. The meaning of the expression was that a person promised or undertook. It was based on the simple idea that if A undertook to perform some act for B and misperformed what he had undertaken, and B was thereby damaged, B could recover against. It was an action which grew out of trespass on the case. In an old case which took place in 1348, A had undertaken to transport safely across the river Humber B's cattle. He overloaded the boat and the cattle consequently perished. B brought an action upon the case against A, who was held liable. Forms of action abolished. Forms of action were made unnecessary by the Common Law Procedure Act of 1872, the Judicature Act of 1873, and the rules made thereunder in 1875, by which every pleading was to contain only a statement in a summary form of the material facts on which the party pleading relied. But in order to understand correctly the principles of the English law, it is essential for a student of law to have an elementary knowledge of the nature of these various writs. Maitland has said, "The forms of action we have buried, but they still rule us from their graves." In a decision of the House of Lords vis-à-vis Esso Petroleum Company Limited versus Southport Corporation, their lordships rejected the suit of the Southport Corporation for damages caused to their premises by the deposit of oil which was jettisoned from the oil tanker owned by the defendants Esso Petroleum Company by its master. The ship, while being navigated by its master in the channel, ran aground on a rebutment wall in the Ribble estuary. There was a danger that the tanker might be destroyed with the lives of her crew. In order to prevent this threatened danger, the master lightened the ship by throwing overboard 400 tons of oil, which in turn were carried by wind and tied onto the premises of the Southport Corporation. The authorities of the later corporation had to incur expenses for clearing their premises of these heavy deposits of oil. They sued the defendants in damages basing their action on trespass, nuisance and negligence. The trial judge, Justice Devlin, decided that the fact that it was necessary to discharge the oil in the interests of the safety of the crew afforded a sufficient answer to the claim based on trespass or nuisance. The learned judge also found as a fact that there was no negligence on the part of the master, and as such no vicarious responsibility can be imposed on his master, the defendants, the Esso Petroleum Company, for negligence. As to the contention of the plaintiffs, raised only in appeal, that the ship was unseaworthy, their lordships held that, in the absence of any statement in the pleadings of the plaintiffs that the ship was unseaworthy at the commencement of its journey, it cannot be heard at the final stage of hearing. The House of Lords emphasized the importance of the pleadings and finally dismissed the suit of the Esso Petroleum Company for damages in the absence of proper pleadings. Lord Norman said thus, "There was no notice in the pleadings of any other cause of action, such as that the appellants negligently sent the vessel to the sea in an unseaworthy condition. To condemn a party on a ground of which no fair notice has been given may be as great denial of justice as to condemn him on a ground on which his evidence has been properly excluded." In Lating versus Cooper, the defendant negligently drove his car over the legs of the plaintiff, who was sunbathing on a grass plot outside a hotel where cars were parked. She failed to file a suit within the period of 3 years fixed for actions on negligence by the Limitation Act, but filed the suit before the expiry of 6 years, the statutory limitation period fixed for the tort of trespass to the person. The suit was dismissed by the court on the ground that it was substantially a cause of action for negligence, and the technical ground taken for extension of period was of no avail. Lord Diplock said that, though the factual situation also falls within the description of the tort of trespass to the person, it does not cease to be a tort of negligence. It only means that there are two apt descriptions of the same cause of action. It is clear from all these decisions that today, although the judges are inclined to examine primarily the claims of parties from the points of their rights, they would still equally examine their pleadings as well. In this process, however, the modern judges will not allow these ghosts of the past, basing their claims on old procedural distinctions, to stand in the path of justice, clanking their medieval chains. In Mrs. Latang's case, Lord Denning, M.R., remarked while quoting Professor Winfield's definition of tortious liability, thus, "Our whole law of tort today proceeds on the footing that there is a duty owed by every man not to injure his neighbour in a way forbidden by law. Negligence is breach of such a duty, so is nuisance, so is trespass to the person, so is false imprisonment, malicious prosecution, or defamation of character." Now let's understand the substance is predominant. In modern times, courts do not attach so much importance to form as to the substance. If a judge is satisfied that in the case before him there has been an infringement of a legal right vested in the plaintiff, he will be anxious to do justice to the injured, irrespective of technical defects in the pleading. In United Australia versus Barclays Bank Limited, the plaintiff's claim for the recovery of money from the defendant for the wrongful conversion of a cheque was sought to be resisted on some technical plea of waiver of torts, but the House of Lords rejected the contention and allowed the plaintiff's suit. Lord Atkins said, "Fantastic resemblances of contracts invented in order to meet requirements of law as to forms of action which have now disappeared should not in these days be allowed to affect actual rights." When these ghosts of the past stand in the path of justice, clanking their medieval chains, the proper course for the judge is to pass through them undeterred. We can now confidently assert that at the present day the substance is predominant over form, and the rule is ubiges ibi remedium, which means that wherever there is a legal right, there is a legal remedy, or there is no right without a remedy. The general principles of liability are in detail discussed under the headings damnum sine injuria and injuria sine damno. These are the two principles on which whole law of torts is based. In modern times, the law of torts has been mentioned in various Indian laws like Motor Vehicles Act, Consumer Protection Act, etc. With this, I conclude today's topic on origin and development of law of torts in India and England. Hope you have understood it. Thank you for watching. Goodbye.